So thank you very much. So the story goes on with the topic of legal certainty and legal uncertainty, and I would like to connect my research and my presentation to Adam Balázs's presentation. So nowadays my research focuses on the problems of legal certainty, the theoretical problems of legal certainty, and in general, and I especially interested in the problems of legal certainty in criminal law. So today I just would like to raise some issues on the concept of the foreseeability of law as it appears in the interpretation of the European Court of Human Rights in criminal cases. So as we are living in the age of uncertainty, we can say that. The world is changing permanently. Technological, social, economic, political transformations make our life increasingly unpredictable. And at the same time, we are also living in the age of legislation, in which an overwhelming number of legal norms are created to adapt to the changing circumstances. So I think that it is becoming even more and more unrealistic to expect individuals to understand rationally what's happening around them. However, legal certainty and certainty is a very and extremely important value in law. And legal certainty is a part of the value of the rule of law. And in criminal law, we can derive it from the principle of legality and the principle of nullum crimen sine lege. So let me just make some introductory remarks on the principle of legal certainty and the principle of nullum crimen sine lege. The principle of legal certainty is a highly debated principle in legal theory. In the theoretical tradition of legal positivism, legal certainty constitutes a highly significant value that the law must realize. However, according to the proponents of the American legal realism, for example, maintain that this value is merely an illusion, incapable of being fully realized. Nevertheless, even legal positivists acknowledge that legal certainty is a relative idea which can be attained only to a limited extent, as uncertainty is an inherent feature of the law itself, as we could hear from the presentation of Adam. Hence, so the realization of legal certainty is possible only if we are able to accept the inevitable presence of uncertainty in law. And it is also a very disputed issue in legal theory, whether the assessment of the requirements of legal certainty is a matter of morality or is it a matter of formal issues. So this is a question that must be answered. I don't know whether I could answer it, but I will try. I will give it a try in my presentation. And it is also known that the problem of legal certainty is a matter of, or is strongly connected to individual autonomy, because the principle of legal certainty entails that the legal system guarantees individuals the ability to organize their lives in a predictable manner on the basis of their understanding of the law and to foresee with a reasonable confidence which of their actions are subject to legal regulation and what legal consequences are attached to their behavior. So, and when I interpret the principle of nullum crimen sine lege, I would like to follow the theory of András Szabó, who was a famous criminologist, Hungarian criminologist, and he was a judge at the Constitutional Court of Hungary. I am not a criminal lawyer, so hopefully I will not say any incorrect things in criminal law, but maybe you can correct me if I do. So when I interpret the principle of nullum crimen sine lege, I will follow the theory of András Szabó, and and following him, I consider the principle of nullum crimen as a political philosophical idea, which concerns the limits of the exercise of state power. So, in my opinion, the nullum crimen sine lege principle does not merely express the former requirement that the legislature must formulate criminal laws precisely and in an intelligible manner, but also addresses the question of what may legitimately be criminalized. I therefore interpret the principle of nullum crimen as an expression of a kind of a fundamental right, the right not to be criminalized arbitrarily by the state. And as it is also my opinion that this depends on moral evaluation, what could be criminalized legitimately in a constitutional democracy. So as András Szabó puts it, if the principle of nullum crimen sine lege is bound by public and constitutional law, then an act which is under the protection of a fundamental right cannot lawfully be criminalized. The real guarantee of political liberty provided by the nullum crimen sine lege principle can be found beyond criminal law and its doctrinal system. So, following him, I would put it, or I would add his opinion with the statement that the assessment of the realization of the principle of nullum crimen sine lege entails substantive moral reasoning about the possibilities of legitimate criminalization. So the principle of nullum crimen sine lege and legal certainty is expressed in the case law of the European Court of Human Rights in the concept of foreseeability of law. And what foreseeability of the law in the ECtHR's case law mean? You can see I collected some free reasons in the reasoning of the ECtHR. First, foreseeability of law means that the legislator must the criminal offenses clearly and precisely define. So the clear and precisely defined criminal offenses is a part of the foreseeability of law. The second is that criminal law must not be extensively interpreted by the courts to the detriment of the accused. And third, the individuals should know from the wording of the criminal statutes which of their actions make them liable under the criminal law of their state. So this is the main parts of the foreseeability test in the case law of the European Court of Human Rights. So I just, with my presentation, I just would like to raise two questions concerning the principle of the foreseeability of law in the ECtHR's case law. The first question is, I don't know whether I can answer it again, but my first question is whether the requirements of foreseeability can be evaluated according to a relatively objective test. Is it possible, or do we have, or can we create an relatively objective test to assess the requirements of the foreseeability of criminal law and law in general? And the other is that can foreseeability be considered as a moral and not just a formal idea of law? Because in my opinion, in the case law of the European Court of Human Rights and in general also the principle of nullum crimen sine lege or the principle of legal certainty is considered as a formal requirement and not a moral requirement. As far as I can see, the problem of foreseeability is relevant and the most and much more interesting in the so-called hard cases, which entail a certain degree of legal uncertainty. So, as far as I can see, uncertainty in law has many faces. The assessment of the requirements of foreseeability must rest on different lines of reasoning, depending on the particular type of legal uncertainty involved in the case. So accordingly, I just thought that it is worth examining in what ways hard cases manifest themselves in the case law of the European Court of Human Rights. And I believe that as I examine the case law of the ECtHR, maybe there are more types, but I found 3 types of so-called hard cases in the case law of the ECtHR concerning the foreseeability of law, of course, and the principle of nullum crimen sine lega. The first type comprises, I think, those cases which do not directly concern the violation of a fundamental right. In such cases, the wording of the national statute is vague or ambiguous. For example, such questions, these questions are raised as what qualifies as a weapon or what qualifies as a medicine. In the case was raised such kind of questions. In such instances, the court is generally required to clarify the meaning of a particular term linked to mostly a professional activity. And the assessment of foreseeability in these cases depends on whether the perpetrators acted with the level of care expected within their profession. So here the court does not meet the burden of deciding deep moral issues, and the assessment of foreseeability can be based on mainly formal conditions. The second type with which I met while I was examining the case law of the court, the second category of cases, the issue of foreseeability is linked to the violation or the conditions of exercising of a fundamental right. In such cases, in my view, moral reasoning cannot be avoided, as the question of foreseeability is intertwined with the moral conditions underlying the exercise of the fundamental right. Mostly, the fundamental right in these cases is the freedom of speech, the right to freedom of speech. For example, in the Kokkinakis case, was the question that whether the accusation of the defendant for proselytism was or could be foreseeable could be foreseeable by the defendant. This proselytism means the act of making efforts to change someone else's religion by speaking to other people and by convincing them, and the court had to decide whether this kind of action is under the protection of the freedom of speech. That do I have the right to convince others to change their religion or not? And is it foreseeable for the defendant that he will be held liable under criminal law because of he tried to change someone else's religion by convincing him or her? So here, I think that moral reasoning somehow cannot be avoided when we would like to know whether the accusation and the punishment was foreseeable for the defendant. And the third category of cases, I think, primarily involves the court's assessment of the retrospective application of law in relation to crimes against humanity and war crimes. Here, the court must determine whether the domestic courts of the member state convicted the defendant in accordance with the Article 7 of the Convention, in accordance to the nullum crimen sine lega principle, in cases where the accused had committed grave acts against innocent persons under a previously dictatorial regime. In the third case as well, I maintain the same position. The question of foreseeability cannot be addressed without recourse to moral reasoning. what kind of questions are raised by these cases. For example, can it be expected of the defendant years after the commission of the act to have foreseen that his actions would later be classified as genocide, for example? Or a similar question may be raised in connection with the case of the East German border guards. For example, that can it be expected that those who acting under orders shot individuals who attempted to flee from East Germany to West Germany should have foreseen that they might later be held criminally liable for their actions? So as far as I can see, these two, the second and the third types of cases, hard cases, as we can call them, in my opinion, moral reasoning cannot be avoided when we would like to assess the requirements of foreseeability of law. And my conclusionary remarks are coming. So, as I stated, that the assessment of the operation of foreseeability of law cannot rely solely on formal criteria, such as whether the wording of the law is linguistically clear or whether the court has developed a coherent line of case law. The problem of legal certainty, I think, is dependent on moral reasoning as well. I would not like to say that the question of foreseeability is totally a matter of moral reasoning. However, I would say that the European Court of Human Rights does not take the responsibility of engaging in moral reasoning when it would be necessary. And in my opinion, the key intellectual tool, doctrinal tool for this reasoning in the case law of the ECtHR could be the so-called concept of essence of the offense. The court uses this idea or uses this concept very often in its case law and in its reasoning when it would like to determine whether the domestic law and the judgment of the domestic courts were foreseeable for the defendant. And the court uses this kind of concept, that essence of the offense. And as far as I can see, this concept is about the nature of the criminal offense. What can be the nature? How can we determine the nature of the offense? And in my opinion, the nature of the criminal offense can be approached in several ways. Maybe we can try with the natural law framework. Within the natural law framework, one may ask whether there exist forms of conduct and forms of behaviors that by their very nature, independently of legal regulation, may be regarded as criminal. In the British criminal law scholarship, such cases are referred to by the term mala in se. They say that there are some criminal offenses in our societies which are wrong by their nature, independently of their being regulated by criminal law. And maybe the court could use this kind of framework for assessing the foreseeability of law in such cases. Sometimes the ECtHR uses this kind of reasoning, that it says that the defendant should have known that he would be held liable by according to criminal law, because the very nature of his or her act was very grave, was very serious, and he or she should have known that the nature of his acts were very, very grave and very, very serious. Or the other kind of framework, maybe we could choose the Dworkinian framework of legal reasoning for the ECtHR. The Dworkinian model of legal reasoning is not based on natural law, yet rests on the idea that moral principles, which justify the law as a whole, also form part of the law. So these principles, these moral principles, may be relied in the interpretation of law in hard cases. So legal certainty in these cases entails that the law and judicial decisions must be compatible with fundamental moral principles as well. As Jeremy Waldron puts it may be that the values protected by the rule of law also require that the law should not, on the whole, make demands on citizens which are radically dissonant from ordinary ways of thinking about moral conduct. The demands of law and the process of legal reasoning should not, on the whole, be morally counterintuitive. So that is why I made efforts to invest or to integrate moral reasoning and morality into the assessment of the requirements of legal certainty. Maybe I am wrong, because legal certainty is a former idea in the tradition of legal theory. And when cases raise moral issues, such the second and the third type of cases in the ECtHR's case law, in my opinion, that moral reasoning cannot be avoided. And somehow we should integrate these moral issues in the problems of legal certainty. Maybe I am wrong, maybe you can correct me, but this is my opinion on this topic. And the European Court of Human Rights does not take the responsibility in every cases to engage in this moral reasoning and to speak about the nature of a criminal offense entirely. So thank you very much for your attention.